What's your name, sir?
Why vice versa?
Oh, okay. Is your client here?
She's on her way. I just called her and she said she was on my part.
Freeman. I have nothing.
Perfect.
My name's Tom.
A little early.
Okay.
They just want the door open back there.
Oh, yeah, that's fine. I don't think we're calling anything. I don't think we have anything ready, do we?
I did double check.
I don't see Mr. Mills.
We have people here, but I'm not sure exactly which, all the attorneys being out here.
Yeah, I haven't seen the attorneys. Which matter are you here on, sir? Thibodeau.
We're ready for that, Your Honor. I'm going to report an update.
Yeah.
Okay, let's do Thibodeau.
That works. She's here. She's all worried about it.
Okay, on the record in the matters of people of the state of Michigan versus Kaylee Thibodeau, file numbers 23-01343 and 23-02379, council appearances.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. Attorney Derek Etchell, supposed defender on behalf of Ms. Thibodeau. She is not present today. I have Mr. Lee standing to my right. I'm assigned to her felony, Your Honor. Mr. Lee is assigned to her misdemeanor.
Say with the date and the time that was set for a review. So she was supposed to be screened for drug court. She was in Clinton County. Were we able to get her screened?
Yes.
Yes, Your Honor. Your Honor, it's my understanding she was screened as eligible for drug court on or around December 5th. However, in her Eaton County case, it's come to our attention that she's been referred to forensics for a competency evaluation. I think that was done. Go ahead, Mr. Lee has the date.
It was done on November 2nd, Your Honor.
November 2nd, Your Honor. I tried to reach out, or I have reached out to our attorney, Eric Tomel, to get updates. I haven't received any response from him yet. Mr. Lee did look at the online ROA yesterday, and it's still listed as being referred with no results received yet.
Okay.
Okay. If I see him, I'll talk to him. I did call him a couple times. He hasn't returned my call.
Okay, sounds good. So what we'll do is, you want me to set this out to see what's going on with that evaluation?
Yes, sir. I think that would be appropriate just to set it out for another review hearing until we get the results from the forensics.
Okay, I will do 60 days.
Do February 15th at 9 a.m.
February 15th at 9 a.m.
Or 16?
The 15th. Any additional matters on this file or these files?
Nothing particular, Your Honor.
Nothing from the defense, Your Honor. Thank you.
Nothing for the defense. Thank you.
Thank you, you're all set.
Thank you, Your Honor.
No problem.
I'll go down.
Okay. Notes, Abbott, Wanji, Robinson. Those are the people we need to see, and Freeman.
I'm seeing Mr. Wilkes is here, and I've seen Mr. Abbott, but I haven't spoken with him yet. And I have yet to see Ms. Wanji. So for Mr. Milks's case,
Well, we'll have Mr. Noakes come here before we talk about his case.
Oh.
What?
Mr. Milks, are you here?
Yes.
I can't see you back there. You wanna know
I'm
why?
skulking, Judge.
Of this giant wall right here. Okay. Walk out for a second, so.
It's fine. She walked out on her own.
Yes.
Okay.
Let's see. Mr. Milk, you're on Kane. Are we running an exam on that?
Apparently we are.
Are you ready to have him brought up?
We can, Your Honor. It probably take 2 seconds. Maybe more than that, maybe 2 minutes.
What will take 2 minutes?
Yes, the PE.
Oh, well, there's that. Okay. We can have Patrick Kane brought up.
Good. I can't hear nothing. Yeah, I can't hear nothing, then I'll hope it is.
The courtroom is muted, Mr. Mercer. We're just waiting for your attorney.
Okay.
Checking in on 15 minutes, right? They got new minutes, so make sure what.
Have we located Mr. Freeman?
I have not seen
Mr. Verser, when did you last speak to your attorney? When was the last time you spoke to your attorney?
I haven't spoke to him. Last time I spoke to him was before I went to court the last time.
I think he's in trial right now. 30th Circuit.
Why did he speak to his client? Let's
What's the
see.
schedule for? What's the schedule
Probable
for?
cause conference. This is not the first probable cause conference. And he knew we were resending this to this day. He didn't say he was going to be a trial. Okay, my understanding is that your attorney is in trial, so we're gonna have to set this for another date so that he can meet with you, okay?
Okay.
You should be.
and 9:30.
Let's not, because I think the reason why we set up a probable cause conference or another one is because there was a misunderstanding on the offer, so you might please, she won't take it.
Okay, so the 28th at 9:30.
December 28th. At what time?
9:30.
At 9:30 is your new date, okay?
28 for 9:30.
Yes,
Okay.
thank you, you're all set for today.
All right.
Ms. Wanji,
Yes,
I think your matter is in person today.
I am, Your Honor. I would like to talk to my client before we start.
Well, he would be downstairs in the jail.
Okay, I'm gonna go talk to him.
Okay, thank you.
Thank you, Your Honor.
No problem. On the record in the matter of the people of the state of Michigan versus Patrick Michael Kane, file number 23-03549, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Good morning, Your Honor. Stephen Notes on behalf of Mr. Kane. Mr. Kane is present and seated to my right at this time.
How are you, Mr. Kane?
All right.
Okay, today's the date and the time that's set for a preliminary examination. My understanding is that we are ready to proceed on this.
Yes, Your Honor.
Okay, any preliminary matters before we call for witnesses?
I just like to make the court aware, one of our witnesses was not properly subpoenaed, so I'm going to be starting the preliminary examination with one of our witnesses and then asking for continuance.
Which witness is that?
The witness who is here or isn't,
This is the one that's not here.
that would be the victim in this case, Jamie Head.
I would note that while Ms. Head is not here, her mother is here, so apparently her mother was properly served, notified. They're going to be offering her testimony just as an offer of proof today, which is going to be almost entirely hearsay evidence regarding a phone call. And then that's going to be it. And the people are going to be requesting an adjournment. My client's currently here on a parole hold at this point, serving dead time. So this is something that just serves the people extraordinarily well at this point. Essentially have my client sit there at dead time.
Okay, so we're calling one witness today?
Yes, Your Honor, and just for the record's sake, I wouldn't be admitting hearsay statements through Ms. Julianne Kemp. The testimony will not be
Okay,
consist of that.
okay, sounds good. Any other preliminary matters?
No, Your Honor.
Not from the fence, thank you.
You can call your witness.
Thank you, Your Honor.
Can I have you raise your right hand? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat, ma'am. Okay, there's a microphone that's in front of you, and this young lady is my court recorder. She has to take down everything being stated here today, okay?
Okay.
So you want to make sure your voice is loud and clear like you're doing now. And then your responses must be verbal. You can't do head nods and shakes alone. You have to give me a yes or a no, okay?
Aye.
Can you hear me?
Yeah.
Okay, you have to give me a yes or a no. Okay, you can hear me clearly though?
Yes.
Okay, if there is an objection by any of the attorneys, you would stop speaking. I'll make a ruling on that objection, and then I'm gonna tell you if you can give that answer or not, okay?
Okay.
I want you to first give your first and last name and then spell both of them.
Julianne Schaefer Kemp, Julianne Schaefer Kemp.
You can proceed, counsel.
Thank you. Good morning. What is your relationship to Jamie Head?
I'm her mother.
Did you receive a text from Ms. Head on November 25th?
And Your Honor, this is me, my first objection just regarding text is gonna be a written statement essentially used for proof not asserted, so hearsay objection.
Okay, well, she's can answer as to whether or not she received the text. She can't tell us what's in the text.
Thank you, Your Honor.
Thank you.
Did you receive a text from Ms. Head on November 25th, 2023?
Yes, I did.
And without telling me what the text said, what did you do after you received that text?
I called her.
Did anyone answer the phone?
Yes, after a long time, she did answer the phone. It was very short.
Okay. Could you, and when you say she, you mean Jamie?
Yes. I'm sorry.
Oh, you're fine. Was Jamie the only voice that you heard?
No,
Could you hear how many people?
I could hear a couple people. She was hysterical and I heard somebody in the background yelling.
Was that well, did you recognize that voice?
No,
Was it a male or a female voice?
yes, now.
And what did you do after this phone call ended?
After the phone call ended, I hung up on her and I called 911
Why did you do that?
because she was screaming and she was hysterical and she said he wouldn't leave.
Objection, Your Honor. That-
Oh,
just to hearsay.
Objection sustained.
Yeah, that's okay. You just can't tell me what she said,
okay.
but you said you were saying, do you want to just, you said that you called because she was screaming.
Yes,
Do you know if police were able to make contact with your daughter?
do I know what?
Do you know if they were able to make contact with your daughter?
Yes, they were.
And did you see your daughter in person anytime like in the following week?
Yes, I did.
Was there anything notable about her appearance?
She did have bruises on her neck and she had a busted lip.
And does she normally have those
No,
on her? No further questions.
Cross-examination.
Your Honor, no questions, thank you.
May this witness be excused?
Yes, Your Honor, thank you.
Thank you, ma'am. You may be excused. Any additional witnesses for today?
No more today, Your Honor.
Okay, we'll get you in a date.
I'm sorry, if I may.
Will you want a new date or what?
Well, I'd be objecting to a new date at this time, Your Honor. I know the people just presented one witness, but we don't have anything here that even really begins a treatment. We've got no date, we've got no address. We don't know if this is in the proper venue. We don't know if the court has jurisdiction at this point. There's been nothing established here. All we know is that there was maybe a bad phone call.
There was a phone call on November 25th, 2023.
Then I missed that part, Your Honor, but we still don't have the jurisdiction. We don't have anything else regarding that. We don't have a name. We don't have any sort of identification. Nothing in furtherance of anything like a crime being committed at this point. People are asking for an adjournment. Essentially, they're just bringing someone in here to obtain an adjournment at this point because they don't have the complaining witness, despite the fact that they've been in contact with her.
Agreed. And we started this off by addressing preliminary matters, which included her telling the court that that complaining witness had not been properly subpoenaed.
Correct.
There was no objection at that time.
I thought I objected.
You did
I
not.
thought I'd be asking for dismissal.
You didn't.
If I didn't, then I apologize. I thought I did, but I guess I'm doing that right now then, if nothing else.
Okay, you're making a motion to dismiss because of their inability to proceed.
Correct, Your Honor.
Okay, I'm going to deny the motion because my inclination is that because the witness was not properly subpoenaed and she's advised the court that they've had communication with this victim, they're only going to reissue this before your client makes it back to the facility he's being held at. Only for us to have to figure out how he can be rearranged. So this matter will be adjourned.
January 4th at 9.
January 4th at 9 a.m. Bond is set at 50,000 cash surety with a no contact order that will continue. Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing further to look past. Thank you.
Thank you. You're all set. On the record in the matter of the people of the state of Michigan versus Crystal Bolden, call number 23-02912, council appearance.
Assistant Prosecutor Steve Strasky on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Ms. Bolden Hooper, who is present in walking.
How are you, Ms. Bolden?
Okay, how are you?
You doing pretty good. Did you forget what time your court date was?
No. No.
Where were you?
On my way here. 7 in the morning.
Okay, today was the date set for sentencing. You have a pre-sentence report. It was prepared back on December 11th, 2023. Mr. Carter, you received a copy of that report?
I have received a copy of that and I have gone over it with my client.
Any reason to make updates, corrections, or deletions?
She did not advise me of any updates or deletions or corrections.
You can make allocution at this time.
Thank you, Your Honor. Your Honor, we respectfully request that you follow the parties' Killebrew agreement. We also ask you to follow the pre-sentence investigative suggestions as far as terms of probation and what Ms. Bolden Hooper can do to help her with us if a situation like this arises, which includes a parenting program and also to complete 24 hours of community service. We'd ask the court to consider waiving any fees and costs that the court can waive. She is on very low income. She is trying to raise a family on such a very low income. I believe it's only $500 a month. We'd ask for your mercy in that area. Thank you.
Do your client want to make a statement for herself?
This was a no contest plea. There's some issues with the custody, issues with the child that was involved here. So on my advice, I asked her not to make any statements regarding what happened, but obviously she could make a statement of how remorseful she is that she finds herself in this position.
I love my children with all my heart, and I would do anything for them. And however, I feel like this was blown out of proportion. I'm willing to do whatever it takes to make sure I take care of my children.
Okay, there was a no contest plea in this matter to count one, or amended count one of interfering with the police investigation. There was a Killebrew agreement to no additional upfront jail with a probation sentence upon successful completion of probation. It's a delayed sentence. I'm not 100% following that. Was she supposed to have a delayed sentence, or was she supposed to be sentenced to probation?
It was a delayed sentence, and normally on delayed sentences, I believe the court can order her to do certain things. But
Requesting status under 7411.
you know, I'll be honest with you, I did not catch it. It's 771.1.
Yeah, the plea
That was-
sheet says 7411.
Okay,
Okay,
I did not catch that,
okay,
but it was a delayed sentence.
got it. Okay, sounds good. And it's the prosecutor's intention, I would imagine, is it to dismiss this upon successful completion?
That is correct.
Okay. That's not what was indicated here. Okay, I will make sure that's properly indicated on the record. The pre-sentence report indicates that they found Ms. Golden to be honest and forthcoming. And I'm sure due to the statements that you've made, Mr. Carter, she had declined to provide a statement regarding the offense. She stated here today she believes the matter was blown out of proportion, which does cause the court some concern as it relates to accountability.
And I can agree with that. And this was a case that I was willing to proceed forward and defend to her to the best of my ability based on these facts. And when she says blown out of proportion, I don't necessarily think that what she was saying about what happened to the child was blown out of proportion, but how they conceived her of trying to interfere with a police report. And I'd have to agree with her at some point. But also I believe that looking through the facts, this was the best resolution regarding what was in the police report and how other people could have perceived it.
Understandable. I am going to adopt the Killebrew agreement. We'll have sentencing set out for 6 months under 771.1. While you're in that time period, you will have the following conditions that you need to adhere to, okay, ma'am? You need to attend parenting programming. I'm not sure if you're still doing that. Are you already doing that? Then you'll just provide verification of that to probation, okay? And are you employed?
Yes.
Where are you employed?
Not DoorDash.
You'll continue with your employment, and you will provide evidence of that to our probation department. You're not to use or possess alcohol, marijuana, or controlled substance without a valid prescription. You're not to engage in any assaultive or threatening behavior, and you're not to purchase or possess a firearm, ammunition, or weapon of any kind, okay?
Yes.
I'm not gonna order that you engage in random testing at this time.
The people would also be requesting that she take part in moral recognition or cognitive behavioral therapy as a part of conditions.
I will order MRT. And you said behavioral therapy.
Yeah, moral recognition or cognitive behavioral therapy.
No, I'll do MRT at this point. I am going to.
Your Honor, and I can appreciate that request. My client has fully, since this thing happened back almost a year ago, has fully completed with CPS, has been doing types of therapy already. I believe this would just be duplicate of what she's been handling, because this is a CPS case that really, they got involved right away. My client voluntarily, without a petition ever being filed, did services. We had the CPS worker come here at the time of the plea taking to express that with the court. And I understand the people's position regarding that perhaps there might be something here, but all these people have been involved and had given her services of her needs, and I don't believe that that's necessary at that point, at this point.
This is not a CPS case, this is a criminal case.
I understand.
So I don't know what she was involved in. I don't even know, other than what was put on the record by way of the police report that I read into the record. What things that you're saying that would cause this to be conceived as or perceived as being blown out of proportion. And so I have before me a situation where I need to make sure that before this case is dismissed under 771.1, that there is some accountability and some understanding as it relates to her moral responsibilities and duties when it comes to what she should be doing, not just as a mother, but as a member of this community. And so I don't think that asking for her to participate in MRT would be extreme. I'm not even ordering her to do tests during this time. If there is paperwork or something that she's done that she believes is closely akin to what she would be doing there, that can be substituted. She can provide that to probation. I don't know what she was ordered to do as part of the CPS case. I don't have any of that before me. But if that is something that you believe she's already done or something closely akin to that, I'll note here that that can be satisfied by providing evidence of programming that she's completed as part of her CPS case.
Fair enough, that makes total sense. Your Honor.
I'm also going to order that she completes 24 hours of community service within the next 3 months. Do you have any questions at this time, ma'am? Okay, as to fines and costs, there's a $75 crime victim rights fee that must be assessed. It's a $50 state minimum cost that must be assessed. A probation oversight will be assessed on this because they need to monitor this case for the court. It's $30 per month, okay? Ordering for 6 months, that's $180. However, you do have the right to request to be discharged early after 90 days of being under this court order, okay? If you don't have any violations, if you complied with my requirements for you to complete parenting class and either complete MRT or provide evidence that you've done something very similar to MRT as part of your CPS case. If you've done that without any violations, you can make a motion to the court for early termination of your status under 771.1, okay? And you would do that by either requesting a form from our probation department. It's called the MC 512 form, or you can get that off the court website directly, okay? I'll waive discretionary fines and costs at this time. If you do end up doing the full 6 months under the court order, your fines and costs are going to be $305. And you can make monthly payments on that, okay? Have any questions at this time? Has your address changed since the last time you were in court?
No.
When you leave here, you should go down to the fifth floor, check in with probation before you leave for today, okay? You just want that for the record.
No, thank you.
I think some people, thank you.
Oh, let me give her a date 6 months out. I think June 21st. June 21st at 9.
Thank you, Your Honor.
No problem, but obviously if this case is dismissed that before then, if I receive a nollie before then she won't need to appear that day. Okay?
Thank you.
Thank you. I gave you the wrong file. Can I see that one back, please? Okay, let's see. Mr. Abbott,
Morning, Your Honor.
good morning. Cowden, do we need him brought up now?
We probably don't need it.
Um, I'm gonna check the hallway from.
Sounds good. I don't know where Miss Wanji is, but she must be downstairs. Pearson. Where Robinson is? Sounds like her. Oh, Miss Donnelly. You know where Miss Donnelly is?
She was in Florida last time I seen her.
Okay, we take care of person for today. On the record, in the matters, of the people of the state of Michigan versus Zachary Edwin Cowden, file number 23-02982, 23-01265. Council appearances.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office, representing Mr. Cowden. He's in custody on the third floor.
Are you waiving his presence for this purpose?
Yes, sir.
Okay. Date and time that was set for preliminary examination and a PA 53 contempt hearing. Do we have necessary witnesses here?
No, we do not, Your Honor. After our best efforts, the witnesses are not.
How do you want to proceed, Counsel?
Move to dismiss on both files, Your Honor.
Your motion to dismiss is granted. I will get you a nollie for your client.
Thank you, Your Honor. I'll take it down to him.
Yes. This was the one that. victims came for. We have process. Okay,
Your P number? Oh, it's 86964. Okay.
Robinson,
Yes, ma'am.
let's see. Is this Mr. McPherson you have here?
I believe he's outside. I just need to talk to him real quick. I also have Mr. Foreman, and then Mr. Murray, who's not here. He's in.
Okay, they should both be downstairs. Are we, where Foreman is downstairs, who's the other person?
Mr. Murray, I found out about 2 days ago that he's in Clinton County.
Yeah, that was reset.
Yeah, okay.
Okay, so are we running, Foreman?
I don't believe so. I think the state is going to be asking for a continuance on this.
Okay, you want us to have him brought up now?
That would be fine.
Okay, we can have Jaquan Foreman brought up. Ms. Donnelly.
Hi.
Hi, Wheeler.
Yes.
Are we running Wheeler?
I don't know. I'm gonna go downstairs and talk to her before she's brought up.
Okay. Mr. Zany.
Good morning, Your Honor. How are you?
I'm good. How are you?
I'm well, thank you for asking.
Are you running an exam today?
Probably walking through it. I get out of breath when I run, Your Honor.
No,
Yes.
maybe,
Yes, ma'am.
maybe
I
not running,
anticipate-
maybe. Okay, sounds good.
Yes, ma'am. Sorry for not standing there.
Mimi?
Okay.
The 28th at 8:30 of December. Yeah.
Is that what?
Oh,
Thank you.
I'm sorry.
One for you and your client.
Just one for the client. Thank you.
Okay, on the record, in the matter of the people of the state of Michigan versus Amari McPherson, file number 23-03347 FY, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. McPherson, who's standing to my right.
Okay, how are you, Mr. McPherson?
Good.
Today is the date and the time that's set for a preliminary examination. Are we continuing with our exam today?
This will be a waiver, Your Honor.
Unconditional waiver to circuit court?
Correct, Your Honor.
Correct, and people would also be waiting.
Okay, and was there an offer at all for negotiations when continue in circuit?
They're to continue in circuit.
Okay, and Ms. McPherson, you understand your right to have a preliminary examination? Ms. Robinson, you can come and out of this. You understand the purpose of the preliminary examination? You understand that you have the right to have the prosecutor put forth evidence sufficient to establish that there's probable cause that a crime was committed and probable cause to charge you with the crime? You're willing to unconditionally waive that today? Is anybody making any promises to you to get you to waive your examination? Has there been any threats made to you? You understand that once you waive, you will not have a hearing on probable cause in the district court and the case will be sent to the circuit court and you can't change your mind? Okay.
And approach, Your Honor.
Yes, thank you. Okay. Find your waiver to be freely and voluntarily made, your bind over date is going to be. What's today's date for? Okay, the 27th of December. That's the date that the circuit court will get the court file from this court. You do not need to appear in circuit court on that date, okay? Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that, okay? And you're still at the address on Thomas Parkway? Your phone number still ends in 7564. Bond in this matter will continue. Any additional matters for the record?
Nothing for the people, thank you.
No, Your Honor, thank you.
You're all set, sir. Thank you. On the record for his matter, if they're just submitting for exam.
The bar offer is to have him plead to a different charge than the single charge instruction. Are we saying he's being deferred to two others? And it's not the right one, or are we saying he's being deferred to the man, but they don't have the date? It's just an
Circuit.
That's for Mr. Coates?
Yes, Your Honor.
Okay, I don't believe you have a date for your exam yet.
That's right.
Okay, and you're just gonna continue?
Yes, Your Honor.
Okay, let's get you a date.
February 9th at 9.
Does February 9th at 9 work?
Yes, it does, Your Honor.
Okay, we'll continue to examine at that date, so you're all set.
All right, thank you. Have a nice weekend.
Same to you.
This is Mr. Foreman.
On the record in the matter of the people of the state of Michigan versus Jaquan Foreman, file number 23-03603, counsel appearance.
The prosecutor, Paige Petrosky, on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Foreman.
Okay, how are you, Mr. Foreman? Okay, today was the date and the time that was set for a preliminary examination. How are we proceeding?
People be asking for a good cause adjournment. The officers who are called as witnesses in this case are assisting in a federal missing persons search, and so they're unable to be present and testify today.
No objection to the good cause.
Due to the reason the officers are not here, the court will find good cause to adjourn the matter, and we'll reset this for a new date. February 9th at 9:30.
Your Honor, would it be possible to get a date that's a little bit closer to where we are? He's being held on this case and through no fault of his own, obviously. The exam
There's
had-
absolutely no possibility. I'm overbooked.
Would Your Honor be willing to consider a reduction in bond then at this point?
A bond in this matter was set at 100,000 cash surety. There's count 1, weapons, ammunition, possession by felon. Count 2, weapons, firearm devices to convert semi-automatic to automatic. And then there is a habitual offender second offense notice. Is he currently on parole, probation, or did he have other matters pending?
Not that I'm aware of.
At the time of his arraignment, he was on probation with MDOC.
He is on probation in Eaton County.
I just asked, was he currently on probation or parole?
Oh.
Yeah, due to a couple of factors. He has a record of non-appearance to court, which is a concern for his willingness to return in his own recognizance. The other issue is that he's currently out on probation. I see Eaton County MDOC probation out of Eaton County for carrying concealed weapon, other prior convictions that were similar to the charges that he's being held on. Let's see here. I think the bond was set appropriately, given the nature of the charges and his prior criminal history and failure to appear in court. So the bond will continue as set. And then this matter will continue to exam on February 9th. Any additional matters for today?
Thank you. What was the time on February 9th?
9:30. Thank you, you're all set. Let's see this one, just come back up here. In a- Charlie, do we need to bring the client up?
Yes, I'm ready, Your Honor.
Running an exam?
You're not. No, we're not running an exam, but we do have a PA 53 also tied to it. I think we'll have a plea.
Okay, sounds good. And then after that, we'll,
But it's just the felonies getting dismissed. It'll continue as. Yes.
Ms. Wanji, do you need your client brought up now?
Yes, Your Honor.
Are we continuing to our exam today?
He's still making up his mind.
Hopefully he'll have it by the time we bring him upstairs. Okay, AAG Logan, are we ready on Sheridan?
We are, Your Honor. Good morning.
Good morning. On the record in the matter of the people of the state of Michigan versus Marion Ellen Sheridan, file number is 23-02222, council appearance.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Your Honor. John Freeman on behalf of Marianne Sheridan.
Okay, and I see Marion Sheridan is present via Zoom. Today was the date set for probable cause conference. I don't believe that this matter has been scheduled for an exam yet. Is that accurate?
That is, Your Honor.
That's correct, Your Honor.
Okay. And so there also was the issue of a motion. I think the motion was to amend the bond because of out-of-state travel. Yesterday, we had a portion of an exam ran for about 6 of the co-defendants, at which time the court did amend the bond conditions for all the co-defendants, removing the travel restrictions. So I don't believe we need to address that motion.
Yes.
Very
Unless
good, Your
there's
Honor.
Okay, and so we just need to set this for a date for exam, is that correct?
Your Honor, I've got a request of the court to actually set another probable cause conference. I can appreciate that the court may want to move this case. As I said the last time we were here, this case is very unusual. And to make a long story short, my office just received earlier this week very voluminous materials from the Attorney General's office. That material contains emails, text messages, and a very lengthy interview that somebody involved in the case had with the Attorney General's office. And I think that that material may very well be pivotal and critical to the defense in this case. It may contain exculpatory information. And I'm going to need some time to be able to digest that. I do not think at this point that it's prudent, at least from my client's perspective, to set things for an exam. There's also a secondary issue, and that is recently in late November, a federal civil suit was filed by one of the electors in the Western District of Michigan seeking an injunction against the prosecution to enjoin the continued prosecution of at least the one named plaintiff who is an elector that's affiliated with the overall big picture in Ms. Sheridan's case. So for those reasons, and also just in terms of scheduling goes, I'm asking for a probable cause conference in March.
I'm not going to put a probable cause conference out in March. I'm not even going to run this exam separately. As I stated before, I started an exam for 6 of the original 16 co-defendants this week. It is a extremely heavy burden, not just on the court, but on the prosecutor and all the witnesses and to try to present this case and to bifurcate it and then separate it off again and then silo Ms. Sheridan off would really put the court at an extreme burden. I am already struggling finding time to complete the exam for the 6 people that have already started. This is an examination that probably will take more than 6 days to complete of the court's docket when I have other things that need to be put on my docket, and we're presenting the same evidence and with the same witnesses.
I appreciate that.
When you talk, I was very quiet. And I expect the same respect when I talk. I'm not setting this out so that Ms. Sheridan can have her own examination. She will run her examination with the other parties. I set this out for an additional probable cause conference back in August because you represented to the court that you were going to be filing a motion. And it's now December. The only motion I got was so that she can travel. I've received no motion relative to evidence. This matter is set for a preliminary examination.
Your Honor, may I respond?
When's the next examination? January 31st.
Your Honor, may I respond?
You can respond.
Thank you. First of all, I told the court that we were evaluating whether we were going to file a motion. I never said for sure that we were going to file a motion. So that's a big difference. The second thing,
it doesn't matter. It doesn't matter. We've not received any motions. You've had more than enough time to not only evaluate whether or not you were going to file such motions, to have
I'm
those
not
motions
asking
filed.
for more time to file a motion.
Okay, we're off the record. We're done.
Your Honor, I need to be able to address the court.
Because when you spoke, I was quiet, and you think that you're going to disrespect me and continue to cut me off and talk. And it's not going to happen. So we'll see you on the 31st for your exam unless you file some motions.
Your Honor,
Thank you.
May I speak?
No, I'm off the record. I'm moving on. On the record in the matter of the people of the state of Michigan versus Clifford Frost. File number is 23-02212, council appearance.
Good morning, LaDonna Logan on behalf of the people.
And good morning, Your Honor. Kevin Kievsky, P74 153, appearing on behalf of Mr. Frost, who appears with me by Zoom and no objection doing so. Mr. Frost, can you please state your full name for the record?
Clifford James Frost.
Thank you. Today was the date that was set for a probable cause conference. Let's see. And that was to address setting this for another examination. I don't recall, or I don't have in my file, receipt of any additional motions that's been filed since that date. Is that accurate?
That is correct, Your Honor. We did have the C8 or summary disposition motion, which was denied, argued in front of the court. As brother counsel stated in his prior appearance, or right before this particular appearance for Mr. Frost, there is a 1983 claim that is currently pending against the Attorney General in her official capacity. I'm in no way, shape, or form stating that that should impact the current case. There has not been a stay issued or anything like that, nor is this an attempt to seek a removal. But that case number, just for the court's record, is 23-CV-1226. It's before Judge Jonker. And when it comes to that particular judge, he actually asked for a briefing on our motion for expedited consideration. I believe the Attorney General's office submitted their response to our motion this past Wednesday in federal court. With that being said, I did hear the prior case being called, and certainly we hope that if this court does schedule us for a preliminary examination on January 31st, that we would hope to have resolution as part of that 1983 claim in federal court done beforehand. So I just wanted to offer that as information to the court.
Thank you. I've noted that information in our file for information purposes as it relates to the pending case before Judge Jonker in the Western District. Again, as you indicated on the record, that has no bearing on the proceeding in this matter unless we get unless you grant or are granted injunctive relief. Until that happens, or if that happens, we're going to continue with this docket, and this matter will be set for a preliminary examination January 31st at 8:30 in person at the court. 30th.
Thank you very much.
30th. I'm sorry, it's January 30th and 31st, actually.
Okay.
Yes, yeah.
In person at the court. And just based on the nature of how the first one is proceeding, I would imagine that this is going to be reset for additional days after that. But as of right now, we're going to do those 2 days, and then we'll reset additional days at the conclusion of the 31st date.
Understood, Your Honor.
Okay, and again, as it relates to bond conditions, I don't believe that I received any issues as it relates to your client's ability to travel, but the court has amended the bond in this particular file as they've done in each other co-defendant to remove the travel conditions. Any additional matters for the record?
No, we're just very appreciative of the bond conditions being changed, so that pretty much nulled or avoided any type of ask. So I appreciate that on behalf of the court.
I would say I've never received more motions to travel than in this case. It's a traveling group of people. So it relieves them and it relieves me. Happy holidays. We're off the record.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, may we recall Ms. Sheridan's case related to the date?
We may not. I'm off the record on that matter. Thank you.
Mine's set for the 31st, Your Honor.
It's the 30th and 31st. You'll get a notice in the mail.
Well, I do have a scheduling conflict with a criminal sexual conduct, the first degree exam.
You can file a motion. You can file a motion.
Okay. So just to be clear, it's originally the court said it was going to be the 31st. It's now the 30th and 31st.
It's the 30th and the 31st. We set it for 2 days. And that date's been set for that group for quite some time. When I stated the 31st, I misspoke. It should be 2 days. It should be the 30th and the 31st at 8:30. So
Okay,
you will see a copy of that in the mail.
Thank you for the clarification, Your Honor.
We have here, Wheeler.
Yes, Your Honor.
Okay, on the record, in the matter of the people of the state of Michigan versus Shanique Wheeler, file number 23-03123, counsel appearance.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan, P number 83466.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Shanique Wheeler, who is present and standing to my right.
How are you, Ms. Wheeler? You're not good? Is something going on other than the fact that you're in jail?
That's it.
Okay, well, I can understand why you're not good then. Today was the date and the time that was scheduled for a preliminary examination and then a PA 53 bond violation hearing. How are we proceeding?
Your Honor, in regards to the exam, our officers are not here, so I expect a motion from the defense, Your Honor.
Why are your officers not here?
Unfortunately, the officer that this actually happened to no longer works for the department.
Yes, Your Honor, we would be asking that the resisting an obstruction be dismissed without prejudice.
Okay, motion to dismiss count 1 is granted. So count 2 and 3 are misdemeanors. And the same officer was for count 2.
There were other officers there that could testify to counts 2 and count 3.
Okay. And then count 3 being assault and battery. Okay. We'll set that for a pretrial. Was there an offer?
Your Honor, there has not been an offer given at this time. Due to the issue with this resisting obstructing an officer, we need to reevaluate the case and send an offer over.
Mr. Lawcock? His audio's not started, so that's why he can't hear us. He should call his attorney. Pre-trial date? January 16th at 8:30. Do we have a witness here?
We do, Your Honor.
How are we proceeding on the PA 53?
It is the people's understanding that there may be a plea in that regard. Bart Buxton.
Now, what was it?
Here.
Yes, yeah, it doesn't matter.
All right.
What's your P number?
P number 83466. I'm
I think
approaching
he-
your clerk with my name as well.
I think he was writing his name down. Yeah, that's what I was trying to learn.
Your Honor, we're ready to proceed.
Okay, there's gonna be a plea. So you were previously arraigned on a violation of your bond condition. It says 2 PA 53 violations. I have here a police report indicating that on December 12th, 2023 at 9:50 in the morning, that you allegedly violated your bond conditions, which was to not have contact directly or indirectly with the Nequam Wheeler. and that you were not to be within 2,000 feet of wherever he lives, works, or goes to school. The allegations are that you violated those bond conditions. And so you want to enter a guilty plea to that, ma'am? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Please put your hand down. Do you understand that a bond violation would constitute a contempt of court order?
Yes.
Okay, you understand that there's a maximum penalty for that?
Yes.
Okay, and that's 93 days in jail and or $7,500 in fine. You understand that?
Yes.
You understand you have the right to have a hearing today and have witnesses called and evidence put forth to establish whether or not you violated your bond conditions. You understand that?
Yes.
You want to waive that hearing and enter a guilty plea?
Yes.
Anybody threatening you to do that?
No.
Any promises being made to you in exchange for you entering a guilty plea to the violation?
No.
As to the violations, that you violated your bond conditions by having direct or indirect contact with Mequam Wheeler on December 13th. How do you plead?
Guilty.
As the violation that you were within 2,000 feet of wherever he lives, works, or goes to school on December 12th. How do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. All right, Ms. Wheeler, you were arraigned on, when you were arraigned on these charges, were you told by the court that you were to stay 2,000 feet from wherever your brother lived, worked, go to school?
Correct, but this is my house, so that's the misunderstanding of this whole thing.
All right, so on December 12th and 13th, were you at your home on Beaujardin?
Yes, ma'am.
All right, and was your brother also there?
Yes, ma'am.
Okay. Your Honor, no further questions.
This is your house?
Yes, and I've been trying to tell these people this. I gave them my lease. I put a PPO. I went downtown and got the to make them move out the eviction. I've done it all. And
your brother lives at that same address?
Correct. He's not supposed to be, but he does.
You say you have a pending eviction?
Yes, ma'am, I do.
Okay, and you indicated that you was gonna stay at 4009 Hillborn during this matter?
Right.
Okay, but that's not where your address is, correct?
My address is 2925 B Adjournment Drive.
And that's where the allegations that you violated occurred, correct? Okay. Any other factual basis?
No, Your Honor, I have none.
No, Your Honor, people are satisfied.
No, the court is satisfied with the factual basis. I accept your plea, find your plea made freely, voluntarily, and intelligently. The unfortunate thing for you, ma'am, is that, and it's indicated in the police report, both parties have residence or residency at 295 Beaujardin Drive, and I recognize you have a valid lease agreement there, but while there is a pending assaulted charge against you, no contact orders are standard, and you're not to be wherever they're living. And until you can get that eviction proceeding in your favor, so he can be removed from that place, you can't be there unless he voluntarily leaves. You understand that?
Now I do, yes.
Because you don't want to end up in custody because you went to your house that you're responsible for. So it's an unfortunate situation. It's even more unfortunate knowing these are siblings. Nonetheless, I'll accept your plea and you're all set. Your bond will continue.
Your Honor, could, is that the original bond on the case?
Original bond will continue.
Okay, all right, thank you so much.
Thank you.
You're welcome. I just printed her a date for her pretrial. And then part is the Valley for the county. I think we have one more to bring up. Ms. Wanji's client, he's trying to figure out what he wants to do. I think he's gonna know by the time he gets upstairs.
Yes, sir.
Which would you got? Okay.
versus Tyler Maynard, file number 23-03594. Council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Good morning, Your Honor. May I hear everyone? Mr. Maynard, who's sitting in the council.
Mr. Maynard, how are you?
I'm very well. How are you?
I'm pretty good. Mr. Maynard, what portions of no contact with the alleged victim do you misunderstand?
I understand him fully.
Even in the courtroom?
Yes, Your Honor.
So you enter the courtroom, you think that no contact order is lifted?
No, ma'am. I'm sorry.
So what was you doing talking to the alleged victim? How are we proceeding?
People are prepared to run the preliminary examination today. However, it was our understanding that the defense will be calling the victim in this matter. And based off of circumstances and communications that we've had, we believe that once she's on the stand, it'll become a Fifth Amendment, or there'll be a Fifth Amendment issue, and we're worried about self-incrimination on her part.
Caitlin Hennings?
That's correct.
Your defense intended to call that witness?
Yes, Your Honor.
Okay. This is the person that your client thought he should talk to when he entered into the courtroom today? Violating a bond condition, also called a PA 53 violation, is contempt of court order. Is punishable with a maximum penalty of 93 days in jail and or $7,500 in fines. You do have the right to have a contested hearing on the violation. Do you understand that?
Yes, Your Honor.
I'm going to set it for a PA 53 violation hearing before we have the examination. If you're found to be in violation of your bond can be revoked, and some of your privileges can be revoked even while you're sitting in custody. Do you understand that?
Yes, Your Honor.
For the purposes of the alleged bond violation, I do want to plead. We'll enter a plea of not guilty. We'll let you talk to him privately before the next hearing. So we need a new date. This is the original preliminary examination date. So the timeline needs to be addressed. You have the right to have an exam within 21 days of the date that you're arraigned, due to the reason stated by the prosecutor, which is that it's the intention of the defense attorney or to call the complaining witness, and the complaining witness may need to have representation by counsel or be advised of her rights before taking the stand as part of the defense. The court's going to find good cause to go beyond the 21 days, and we'll set this for a new date. February 9th at 8:30 for the exam. February 9th at 8:30 will be the exam and the hearing on PA 53 if we proceed with the hearing on that. Yes, well, it'll be at the same time. Oh, okay. Yeah. Our bond in this matter is set for 10,000 cash surety. There's a no contact order for Caitlin Hennings. That no contact order applies if you're in court, if you're outside the court, if you're in jail, if you're outside the jail, if you're on Pluto, Jupiter, or Mars, or anywhere on planet Earth. You understand that?
Yes, Your Honor.
You are not to have any contact or cause anybody to have third-party contact with her on your behalf. Do you understand that?
Yes, Your Honor.
If you are to bond out, you are to have GPS tether with victim notification if possible. You have to be within 2,000 feet of wherever she is. Do you understand that?
Yes, sir.
Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record?
Nothing from the people. Thank you.
Yes, Your Honor. I understand what my client may have done, but we would like to request a PR bond at this time. My client is indigent and he's not able to post the 10,000 surety bond. And I think that after the punishment that the court has done, my client would be more inclined to respect the condition of the bond. The alleged victim is in court. She knows that my client should not be contacting her. I will explain to her also that what the conditions of the bond are for my clients. However, my client, again, he wants to come to court when requested to do so, and he will do so. He's not a flight risk. And besides the mistake that may have happened today, we do believe that he's a good candidate for a PR bond.
How do the people want to respond?
The people would be objecting to the PR bond in this case due to the severity of the charges, the continued attempts to have contact with the victim in this case, and the fact that he has 2 other open cases currently, one in Clinton County on felony charges, including attempted kidnapping, as well as other assaultive charges, and then also an additional against the same victim, and then an additional misdemeanor violence charge, I believe, out of 55th.
I have a defendant is currently on felony probation as well, 44th Circuit and 6th Circuit Courts, and is currently in non-compliance.
That's correct, and he also has, I believe, it's 18, but for the, I'll say 17 open warrants as well.
So if I were to bet, my bet he doesn't follow court orders well because he's not in compliance with the supervision he's supposed to be under. The bond, I think, is more than appropriately set due to the nature of the charges. And so the bond will continue as set. Any additional matters for the record?
No, you're not.
Try to find, yeah, so they're-
I had it for the money around as well. So yeah, it's
This is one more.
they have to do it and then they don't.
That's a plea. I don't see Mr. Zaney.
That's my recollection too.
Oh, Mr. Zaney's back there.
Yeah.
On the record in the matter of the people of the state of Michigan versus Frank Schmidt, file number 23-02825, Councilor Terrence.
Stevens on behalf of the people. Good morning, Your Honor. Edward Zane on behalf of the defendant, Mr. Schmidt. He's approaching to my right.
How are you, Mr. Schmidt?
I'm all right. How are you?
I'm doing well. Okay, let's see. Today was the date and time set for preliminary examination, but there is an offer from the people, for the defendant to plead guilty to an added count 3 of assault or assault and battery under MCL 750.81. It's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines. The people will dismiss counts 1 and 2, and there is a Killebrew, which is a sentencing agreement to no upfront jail. Is that a complete and accurate understanding?
It is from the defense, Your Honor. Just has to be factual basis.
Okay. You asked to do the factual basis?
Alyssa, I would like to ask some questions.
I always do that.
Oh, do you? Okay.
Yeah, no worries.
All right.
No worries. And so I have an advice of rights and the information sheet. You want to accept that offer?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can put your hand down. Is this your signature, sir? Okay, and you've read this advice of rights before you signed it?
Yes, ma'am.
You understand the rights listed there?
Yes, ma'am.
Gone over that, or any questions with your counsel, correct?
Correct.
Okay, so you want to give up each of those rights in order to accept the offer and plead guilty to the added count 3 of assault or assault and battery?
Yes, ma'am.
You understand that that means that you would give up your right to the presumption of innocence. So you're innocent until proven guilty. Do you understand that?
Yes, ma'am.
You have the right to have the prosecutor prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to have that those proofs brought forth at the time of a jury trial. You have the right to remain silent at that trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You have the right to call your own witnesses to your trial or present evidence that you believe further defense to the charges being brought against you. Do you understand that? Anybody threatening you to get you to give these rights up? Any promises being made to you in exchange for a guilty plea? Are you currently on probation or on parole? You understand that a guilty plea could result in a conviction that you may need to report to your employer. You also may need to report a conviction on a future job application. You understand that? And then also a conviction may have impact on where you can travel or immigration status. Do you understand that? As to the added count 3 of assault or assault and battery, you plead guilty, not guilty, or stand mute. On factual basis.
Thank you. Mr. Schmidt, on or about September 12th, 2023, were you in the city of Lansing, County of Hingham, State of Michigan?
Yes.
More specifically, were you at or near 3237 West Mount Hope Avenue in the city of Lansing?
Yes, sir.
All right. On that date, did you have contact with a Jordan Jones?
Yes, sir.
And in that contact, did you put Jordan Jones in fear or apprehension of an imminent battery?
Yes, sir.
All right, and that was a reasonable fear? And you did so by your body position?
Yes, sir.
And your words?
Yes, sir.
All right. Thank you, Your Honor.
Any questions from the prosecution?
No, Judge, thank you.
Court is satisfied with the factual basis on exception plea. I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing February 9th at 9 a.m. When you leave here, you should go down one floor, February 9th.
At 9 a.m.
At 9 a.m., yes. You'll go down one floor when you leave here to our 5th floor to the probation department. You'll check in with them, okay? They'll get you scheduled for a pre-sentence interview so they can provide the court with some information to help me action a sentence on your behalf, okay? Do you have any questions at this time? You can appear for sentences via Zoom.
And if I just inquire the court regarding bond, you have the tether on, given the nature of the resolution, I think the reduction in the charge is continued attempt to return to court, well, it's actual return to court in council. But that's just remove the tether. If you need more as to the contact with Mr. Jones, I can elaborate on that. There's a CPS investigation. He's not in the home with Mr. Schmidt, and they have no contact.
I did the prosecution wants to respond to the bond motion.
Honestly, Judge, Mr. Zaney addressed the only question that I was really going to pose, which was, it was my understanding there were existing orders. And so I'll leave it to the court's discretion as it relates to the tether, to sort of the understanding that not only should he continue to follow the existing orders with other courts, specifically the CPS investigation, but if this court wants to incorporate those, that seems more than appropriate.
Bond and remove the tether requirement. All other bond conditions, including following any CPS or other court orders, will continue. Do you have any questions, sir?
So that needs the tether?
You can get the tether removed. You don't want to lose it though,
No,
because
they'll charge you.
they'll charge you both financially and likely criminally. It's a felony to lose that, okay? It's a felony to lose it. So you want to go back to Ingham County and let them retrieve it off of you properly, okay?
Yes, ma'am.
But don't do that until after you go to the 5th floor.
Okay.
And talk to our probation department. Any other questions? Any additional matters for the record?
No, ma'am.
Nothing. Thank you, Judge.
You're all set?
Can you hang on back there? I gotta regenerate the bond condition.
Sure, we can. Your Honor, everybody have a wonderful, merry happy holidays.
Same to you.
Thank you.
Thank you.